Hi, everyone. My name is DeAnna Baumle. I'm a law and policy analyst at the Center for Public Health Law Research. I'm joined today by Stephanie Odiase, the Senior Manager of Research and Partnerships at the Time's Up Foundation. Stephanie runs the Time's Up research grant-making body under their signature initiative, Time's Up Measure Up, which is a 5-year project looking at the impact of the COVID-19 pandemic on women of color and women in low-wage jobs. We're talking today about a pilot project the center recently completed with support from Time's Up that analyzes laws addressing unpredictable scheduling in US workplaces and the impact of those laws on women both before and during the pandemic. Thanks so much for joining me today, Stephanie. And with that, I'll turn it over to you.
Thank you so much for having me. It's an honor. So let's jump into the first question, which is, can you describe and define unpredictable scheduling laws?
Sure. So in our project, we aim to capture statutes and regulations at the federal, state, and local level that regulate workplace scheduling. There are a lot of ways that governments can regulate scheduling, and we identified several different types of laws within our project scope. The most robust and protective laws we found are called Fair Workweek laws, which are actually packages of several legal protections that aim to directly address unpredictable and unstable scheduling. One of the key provisions in Fair Workweek laws require employers to provide workers with advance notice of their schedules, typically around 14 days. If the employer changes the worker's schedule after that notice period, they are usually required to pay that worker extra for that shift change. And that's the key protection in these Fair Workweek laws, but there are other protections as well, and they typically include the right to rest a certain number of hours between shifts, the right to request schedule changes or flexible schedules without fear of retaliation, and a requirement that the employer provide a good faith estimate of what a worker's schedule will be like from week to week. In addition to these comprehensive Fair Workweek packages, we also identified some standalone legal protections that regulate discrete aspects of worker scheduling. An example of this are day of rest laws, which require employers to provide 1 day off per week to their workers. Others include reporting pay laws, which require employers to pay workers for showing up to a scheduled shift, even if the worker is then sent home for lack of work. Another is split shift laws, which require employers to pay extra for shifts that have a gap of unpaid time in the middle of the shift. Some jurisdictions have also passed standalone right to request flexible scheduling laws, the same provision that's often included in a Fair Workweek package, but without all of those other protections that I just described. On the other end of the spectrum are preemption laws, which are state laws that strip local governments of the power to pass these protective laws. Some preemption laws specifically target unpredictable scheduling laws, while others prohibit local governments from passing workplace regulations and protections. And that's a brief overview of the kinds of laws that we were seeing.
Great. And what would you say that this report uncovered regarding the current US legal landscape?
So we found that most workers in the US are not protected from unpredictable scheduling. There's currently no federal law regulating unpredictable scheduling in this way. But since 2014, 1 state and 6 cities have passed Fair Workweek laws, those more robust packages of protections that I was just describing. Otherwise, some states have passed a standalone protection or two, while several others have passed those restrictive preemption laws, ultimately leaving many workers unprotected. Even in those few places that have passed Fair Workweek laws, there are still many workers left behind. These laws apply only to workers in certain industries, typically food service and retail, although a few places have expanded applicability to other industries like hospitality and healthcare. These laws also usually only apply to large companies within those industries. For example, Philadelphia's law applies only to retail, food service, and hospitality workers who work for employers with over 250 employees and over 30 locations worldwide. That ends up leaving out a lot of people, even within those industries. Finally, we also found that these laws have built in many exceptions to their protections, especially their advance notice and predictability pay rules, which can ultimately undermine their implementation and effectiveness. Despite these limitations, early evidence assessing the impact of Fair Workweek laws has shown that they are effective. And that leads me to a question that I have for you, Stephanie. What is it about these laws that, in practice, makes them valuable for supporting health and equity? How can they help change the landscape for US hourly workers?
Yeah, that's a great question. I would say that there's so much that could be said on this topic, but I think that one of the key things that make these laws so valuable is that they thwart a lot of the effects of precarious employment, which we know from research, including your own, can increase stress and uncertainty, which of course impacts mental health, and can also increase economic insecurity, which of course directly affects food and housing security. So by having unpredictable scheduling laws in place, workers benefit from improvements across all of these factors. And not only do they benefit, their families do as well. So in terms of changing the landscape for hourly workers, a clear takeaway from this pandemic is that workers need more protections that serve them in their totality. So having fair work week laws means that you can have advanced scheduling notice so you can get yourself or your family members vaccinated, or having the right to request flexible scheduling so that people who are also caregivers can accommodate those needs and not feel like they're losing out on job opportunities because of this. So as our society tries to build back, a more inclusive society, a more inclusive economy, and everything in between, labor protections like these become so much more essential because they don't just protect labor insofar as people as workers, but they also support people across their many facets of life as well.
Yeah, those are some great points. And that actually leads me directly into my next question, which is, as you mentioned, we know that COVID-19, the pandemic, has exacerbated persistent issues of inequality and disparities in the workplace, particularly for Black and Latino women. Where do we go from here? Based on what we know now about these laws and their impact, what can policymakers, advocates, researchers, and others do to seize this moment and make sure we're moving in the right direction?
So that's a great question again. And, in terms of direction, arguably the only way we can go from here is up. Between the she session and the great resignation, people, and as you aptly noted, especially Black and brown women, are sick and tired of the pandemic labor market, and understandably so. So in terms of, policymakers and advocates, I feel like there's a lot that the players in the public sector can do. As you've already mentioned, there is no federal protections of this kind for workers. And as you've already touched on as well, only a handful of cities in one state have passed, any form of comprehensive fair work week laws. So this is a key place where advocates and policymakers can really gain momentum. And in addition to fighting at the top at the federal level, there's also a battle at the state level as well, especially in states where fair work week laws currently don't exist, or as you mentioned, these preemption laws are in place, so policymakers and advocates can push there as well. And irrespective of what's going on in the public policy landscape, private sector players can snap their fingers today and put in protection laws across the board to support their workers, which not only is beneficial to the workers themselves, but it also helps companies retain their workforce, which is beneficial to them too. And as you already aptly touched on as well, the current coverage of fair work week laws are quite limited in the industries that they cover and the size of the coverage as well, which mainly focus in on retail, food service, and hospitality. So private sector leaders could easily outpace federal and state legislation in this regard as well by enacting laws across all industries. But I think that's something that's really important, and I'm just echoing another great point that you made, is that in both the private and public sector, at whatever level we want to tackle this at, we need to make sure that there's solid implementation and enforcement of these laws, because otherwise enacting them would just be in vain.
Yeah, that is an excellent point. And, one thing that I just want to add is we already have some of these laws, these comprehensive fair work week laws that exist in one state and 6 cities. So we have a blueprint to see, what works and what doesn't. And we already have some preliminary research that does show, what are the good parts of these laws, what's really effective and what isn't really working so well right now.
Right.
But especially given the variation and the nuances of these laws across jurisdictions, we really need more comparative research to see, which specific provisions, which enforcement mechanisms are really working and which are leaving people behind. And as you mentioned, we know that women, especially Black and Brown women, they're most burdened by unpredictable scheduling and its harms. We need to ensure that any legal intervention that we take is effectively reaching these women and is not instead perpetuating already existing inequities. And we can do that with some more robust comparative research to make sure, who's really getting the benefits of these laws. And then we can take that and we can take, the good things that these laws are doing, and we can expand that. As you said, private companies can do it, but also at the federal level, at state level, we can really move forward and improve scheduling for people all across the country. So thank you so much for joining me, Stephanie, and thank you to our viewers for joining us in this important discussion. If you want to learn more about this project and you want to read our full report, please visit publichealthlawresearch.org. Thanks again.